communicate about the case with anybody outside the jury. Don't do any research on those things.
Thank you. I just didn't want to have any over here.
Jack.
Okay, so the defense has called a Miss Sweet, who apparently is a former prosecutor in the 12th Circuit.
Yes.
And she, if I understand correctly, assigned in the misdemeanor division, the domestic, and the case, the alleged violation of domestic, the T-set was assigned to her.
Correct.
And you expect her to be that she intended to file, that she was waiting on some receipt.
Receipt of the package.
Mailing receipt?
Yes.
That would have shown what, the return?
That Stephanie Murphy gave to Detective Gillen.
And the testimony would be that she intended to file the charge, but then she was transferred out of that division. She left the office. Okay. Because that's one of the temporary assignments that they give to misdemeanor folks. So she left the office. And that's it?
Well, and her training, based on domestic violence training, she believed actually to be a victim of domestic abuse, and that exhibited all the symptoms of domestic abuse. In particular, remaining quiet as a result of intimidation, and going. The state's case is predicated on Miss Benefield going along with Douglas Benefield. For example, on the parent sharing exchange, and the week leading up to the shooting, they put in those 263 messages and the video at the restaurant, all showing Miss Benefield and Mr. Benefield's company as apparently happy and not afraid. And abused, those are the classics exhibited by abused women. They are afraid, the abuser, for fear of reprisal. And what happens is after they reach a state of compliance where physical threats are no longer necessary because they know what the potential is. So they become compliant. That's also what Bruce Ferris is going to enlighten the jury on. And I remind this theory, they have put into play, they injected it, they raised it, initiated it, that because Miss Benefield didn't look scared in the company of Douglas Benefield, and that she was exchanging these text messages with him for the shooting with smiling faces and basically compliant behavior, that shows that her claim to Douglas Benefield on the 27th is a fraud. And we now to explain to the jury why an abused woman would act like that and would, for example, not agree to be present at the first parent sharing exchange. When a child is involved, it magnifies the situation, so that the mom, if she's afraid, in this case Mr. Benefield, because of prior acts of domestic violence, she's afraid for her child. So the mother's going to make it a point to accompany the abuser in an effort to protect her child. That's what we are now obligated to show to properly defend this case. And we can do that meaning and expertise of Samara Sweet as well as Bruce.
Judge, first of all, this witness was not listed as an expert, because if she had been listed as an expert, I would. Just for your Honor's knowledge, we did not have a domestic violence unit at the time. I know our office has in the past. We did not have a domestic violence unit, so she was not in any domestic violence unit. Even if she were an expert, there is absolutely no way that she could testify that she felt that Ms. Benefield was exhibiting behaviors of an abused person, I think it's completely, and the issue of the decline of the injunction, or the fact that Ms. Sweet intended to file, is irrelevant. I can tell Your Honor, and for the court's knowledge, it's because when that package was sent, that showed a date that was a problem for us. And that is why that case was declined. So the decision was made after Ms. Sweet left the office and we received the receipt. So the fact that she would be testifying, I believed her and I wanted to file it, is completely and totally irrelevant.
For the arrest of Douglas Benefield for the delivery of this package, detective came into court and told us that he suspended Deputy Weber's request for us. And we have a communication deputy by way of a public record acknowledges plain as day that it was a violation, that it was during the time that the South Carolina injunction was in effect. But he nonetheless refers it to the state attorney's office. This is the assistant state attorney that was working that case. She would testify, we'd like to put her up for a proffer, that she fully intended to file. She believed it was clearly a violation based on the fact that the court...
Well, I'm just saying, if you want to proffer, let's get her in and proffer, because then all these arguments would happen after the proffer.
Okay.
I haven't made a ruling, so you can make your argument, I can make a preliminary ruling, and then you can proffer.
Yeah.
Okay. Cool. Mr. Taylor, you didn't go outside. So, listen, how about I do this? The jury's out. It's about 3 o'clock. I'm thinking maybe give them a 20-minute, a longer afternoon break. When I do that in the afternoons, I will typically have a deputy escort them down to the jury assembly room where they can kind of spread out. The machines are there, the restrooms, but deputies are with them. Okay? All right, deputy, can you excuse them until about 3:20? We'll get them back up as soon as we can. Thank you.
I do.
Presiding over this case, microphone. There you go to adjust up, down, left, right, however you need it. Speak in a loud, clear voice, you'll hear everything. As you can see, I'll tell you, you're a former prosecutor and attorney. Jury's not here. At this point, the defense is going to proffer your testimony.
Okay.
Afternoon, Ms. Sweet. Will you tell us your full name and spell your last name?
Yes, Samara Sweet, Sweet.
Employed.
I am.
What's your title and where are you employed?
I am the trial lead of counsel at Lydecker, which is a civil litigation.
All right, and you're a Florida bar licensed attorney.
Yes, sir.
At one point, were you a staff attorney for the Manatee County? How long did you serve in that capacity?
I was there from 18 to 2022. It's about 4.5 years, I believe.
All right, and during that 4-year stint, was there any special assignment that you held?
I began with the misdemeanor division here in Manatee County. After 6 months, I moved to Arcadia, so I was in DeSoto County, where I started in misdemeanors and moved up into felonies, where I would have dealt with anything from possessions of controlled substances all the way up to child sex crimes and murders.
Specifically, did you have any training in domestic violence?
We did. Every attorney at the state attorney's office does go through CLE's trainings on how to deal with domestic violence victims, because especially when you're working in the misdemeanor portion, a lot of your crimes are batteries and a lot of them are domestic violence victims.
Can you give us an idea of how many cases you handled involving domestic violence?
Oh. My caseload was 700 when I was in Arcadia, and at least a third of those were probably something domestic.
Did you deal with not only abusers, but the abused.
Yes, most of the prosecutor, my victims were abused individuals.
Were the majority of your victims in domestic violence cases females?
I would say a large amount were females, yes.
Were you assigned, while in your capacity as an assistant state attorney were you assigned a matter involving Ashley Benefield?
I was, yes.
How did that come to pass?
So when I was in Manatee, I had the caseloads with all defendants that had the last names with B, D, or I. So Ashley Benefield's case came to me, and she was the victim in the case that had been assigned to me for a violation of an injunction.
Do you recall specifically the nature of the violation?
It was a package that had been delivered to her, allegedly from her ex-husband.
All right, and the domestic violence injunction that was violated, do you recall from where it had been issued?
It was from out of state. I believe it was South Carolina.
And did you meet with Ms. Benefield?
I did.
Do you remember on how many occasions?
Because when the case first came, there's elements to a violation of injunction that have to be met. We had not yet had all the information, so I did meet with Ms. Benefield, got some more information, and then had to follow up on the investigation. I had to meet with her again after that.
Did there come a point in time when you made a filing decision?
I did not. I had left the office before a filing decision was made. I had been moved to Arcadia at that point.
I should have articulated that question better. Had you, as part of your investigation, reached a conclusion as to whether or not you felt it justified going forward and charging?
I did. I think I was still waiting on some information to prove if the package had actually been sent by Mr. Benefield, and that was the last information that I had left to my predecessor before I left. But I did think that if that information was given, there was enough to file.
And would it help refresh your recollection if I suggested that you were waiting on a copy of the receipt for the package?
Yes, I was who had sent that, and I know I had been in contact with the officers involved.
Do you recall whether or not you were dealing with Detective Gillum?
That I'm very bad with names, so I do not want to say yes or no, sir, if it was Detective Gill. That does sound familiar, but other cases as well.
All right. How was Ashley Benefield when you first met her? Can you describe her demeanor?
Yes, she was very upset. She seemed worried. She had come to my office and she was crying when she was sitting in my office with me. I did think that she was worried about the package that had been received.
Now, was it your practice generally to always meet with the victims in the cases that you were prosecuting?
Yes, it's office policy.
Had you formed an opinion about the genuineness of the fear that Ms. Benefield expressed?
I did believe that she was in fear and worried about that.
And from the investigation that you conducted, did it vindicate, other than the actual label package, the factual representations that Ms. Benefield had made to you? Want me to restate that?
Yes, please.
Yeah, that didn't come out too good. Investigation corroborate the facts that Ms. Benefield related.
Received the package. I know she believed had some weird smell coming from it, and my recollection was that had been investigated, but the package had been delivered to her. I think she said it was close to her birthday, around that date. I can't remember exactly, but it did. The facts that I had investigated, South Carolina, when I reached out to them, had said they had given an injunction for her.
All right, and do you recall contacting the toxicologist with respect to the contents of that package?
I did. She had brought me a toxicology report on that meeting, and I did call the doctor. Now, in all candor, I can't confirm if that's exactly the doctor, but I did speak to someone on the phone who said that Ashley did have weird things in her blood system at the time that did not correlate to someone's normal toxicology But she couldn't say from where that had come from, but that there were abnormalities in that report.
And you say you have considerable experience with women who have been victims of domestic violence. Are certain patterns in your training and experience that you see in these women?
Yes, so a lot of times a lot of these meetings involve an abuser. We have the abuser who has abused someone. By the time they're coming to us, a lot of time has passed. So we always want to explain to them that normally we see a cycle. You have an abuser, he does something wrong. Then it's, I'm sorry, I'm very, very nice. They come back, and then we end up again in this situation with more abuse.
Kind of like a hamster wheel.
Yes.
Did you form an opinion as to whether or not it fit the profile of an abused woman?
I discussed, she did seem that she had been isolated at that time. She was very scared. The way she had spoken to me did give rise. She had mentioned some minor physical issues that had been occurring, but abuse doesn't always have to be physical. Sometimes it's psychological, mental, emotional, and she was in my office when she was sitting. She did seem to be that.
Is it a pattern and practice of abusers to employ psychological intimidation?
I mean, normally a lot of the times in the reports I would have, we would have something of threats or some sort of information leading up, text messages, Facebook messages, things of that sort.
And let me ask you this. Are these abused women, despite their fear, often in the company of the...
I've seen them return back to their abusers, yes.
Have you experienced abused women when in the company of the abuser acting as if everything is fine?
I wouldn't be able to say I've seen them with their abusers, but a lot of times if we were in court trying to present, I would see them come in to defend the defendant that we had or to withdraw claims and that kind of thing.
I guess the point of my questioning is merely because the woman appears, is that an indication that in the company of the abuser?
No.
Why is...
Just, I mean, I have more facts by the time I've seen the investigations, I've seen things of that sort in our caseload. They might be presenting, telling the judge something, but clearly we've seen, photos of abuse. They've sat and given us recollections of abuse, that kind of thing.
You left the office before, and as you sit here today, do you know where the position was?
I believe it was decided to not move forward, so it was dismissed.
That's all, Your Honor.
Close.
When you were in the misdemeanor division in
Started, I want to say, April of 2018. So it would have been 6 months from there, because I think I got out to Arcadia around October, November-ish.
Okay. And was the misdemeanor job in Manatee your first job out of law school?
No.
No. Okay. Did you work, where did you work before that?
Before I worked with Eric Reisinger, I actually did criminal defense.
Okay. All right. So when you talked about the domestic violence training, were you referring to the domestic violence training at the state attorney's office?
Yes.
Okay. And was that the normal domestic violence that everyone is sent to, the class?
Yes.
And how long is that class?
I think it's 4 days.
Okay. And is there any other domestic training?
I know the office does some pretty good domestic training. They'll do PowerPoints, lunch. I think there's some, I don't know if they still do it because now I'm aging myself, some field trips to like the TILA and some of those organizations that work with abused women.
Okay. Thank you. I don't have any other questions.
Thank you.
No, I think that's got it.
All right, ma'am, could you step back out to the hallway, please?
Yes, sir.
All right. She's out. Proponent, you can start with your, there you go. She's waiting in the ante room. Now we got her in the hallway. Proponent of the evidence, argument.
Yes. So Your Honor may remember that Detective Gillum made the allegations 2.5 years later, despite the fact that there was no earlier report documenting what he alleged 2.5 years later in any of his 2 or 3 prior supplements, that Miss Benefield acted completely inappropriately, that he did not believe that the South Carolina domestic violence injunction was in effect, because even though the hearing was on November 3rd, the judge hadn't signed the order till the end of the month. And therefore, he countermanded Deputy Weber's request for a capias. This witness impeaches the statement by Detective Gillum because she was the assistant assigned to the case at the time, and she had made a decision that, in fact, she was going to file, but for the fact that she left the office beforehand. She had conducted the investigation, completed it. All she was waiting on was the label of the package, which, interestingly enough, the court may recall, Detective Gillum recovered from Stephanie Murphy, but it apparently didn't make its way to Samara's suite until after she left the office.
All right. And the objecting party?
Judge, I would object. I don't think she can testify as to anything she just testified to. I think most of it is opinion, and she is not an expert. And even if she was an expert, she wasn't listed as an expert. So she cannot give opinions. And any opinion about whether someone, as a prosecutor, whether someone violated the law or not is inappropriate testimony for court. A lot goes into filing decisions. The prosecutor has discretion the same way police officers have discretion. To add any significance to that, I think, would be completely improper. And so I would object to anything to do with her decision-making with the state attorney's office. And also, as I said, I think there was some information that was gained after she left that played into that decision. But additionally, I think she would not qualify as an expert of domestic violence, and I think even if she could, a lot of those things would be inadmissible anyway, what she would say.
All right. Mr. Taylor, do you have any final thoughts you wanted to put on the record? Any final thoughts? Rebuttal?
That's good.
All right, thank you. So one of the very interesting things about this case as we have gone along is there's been some very interesting, and I think I said the other day, unique legal arguments that have been made. Certainly, I would like to think it's in honor of the Olympics starting tonight that you guys have put me through my mental gymnastics for the last couple of months. So another judge that's here in Manatee County, I hear him say this a lot, and I think it rings true. There are some very difficult decisions that we make as judges, emotionally difficult, legally difficult, factually difficult. This is not one of them. This is a very, very clear and easy decision. I'm going to put the part about Ms. Sweet offering any sorts of opinion as an expert kind of to the side, because I resolved this matter well before I consider that she wasn't listed as an expert and the Richardson aspects of that. And what I want to focus on is the purpose of allowing these other incidents of violence or threats is, as we all know, it's one of the carve-out of, obviously, case law provides an exception in stand your ground and self-defense cases for battered spouse syndrome. Normally, any peculiarities for a particular defendant, PTSD, low IQ, mental health, are the ones that come to mind quickly, are not relevant and not admissible in a self-defense case because it's a reasonable person standard. So battered spouse syndrome is the carve-out, and the idea by once the defendant has laid the predicate of the overt act, allowing either reputation, and if it's reputation in a relevant community, we've all agreed, well, should agree, the case law says that the defendant doesn't have to know about that. It's just reputation evidence. On the flip side, whenever you want to get into specific acts of violence, threats, intimidation, and I know our net that we've casted here is beyond just prior acts of violence. There's also been issues of threats and intimidation. It's come in, it's in. The case law talks specifically about why that evidence is allowed and why all of that is not hearsay, because it's not offered for the truth. It's offered to show the jury what did the defendant know at the time that the self-defense was used. And unlike the mental ailments I mentioned earlier or other peculiarities of the particular defendant, this is just to show why the defendant would have stayed, and even if there wasn't an imminent violence at the moment, why that person would feel terrified, and all the other bad spouse. I won't go into the whole thing. So the issue is not, did this assistant state attorney believe the defendant? Did this police officer take a report and submit a capias, or not issue a capias and send it to the state as a non-arrest? Did this ASA file it or not file it? Did this ASA believe that the defendant was the victim of domestic violence or not? All of those things are completely irrelevant, not to mention prohibited from the witness commenting on ultimate facts or invading the province of the jury. The issue is not the truth or falsity of the violation of injunction or the shooting into the ceiling or any of those issues. That's not the issue. The issue is, was the defendant aware of these prior acts? Example being that the evidence came in regarding domestic violence by Mr. Benefield against his first wife. The way the defendant learned about that was some sort of text message by or between Mr. Benefield and the former Mrs. Benefield. Clearly hearsay. But why does it come in? Because she was aware of it, and it shows some violent tendencies, so she can testify about it, she can talk about it, the jury hears about it to help understand what she knew, and this is in the jury instructions as the attorneys know, what she knew at the moment that this incident was happening. So Ms. Sweet's testimony about whether she believed the defendant or not, whether she was going to file or not, the conversation, whether she thought that the defendant was genuine and legitimately a victim, the testimony that she had some report and she called someone and there were some sort of abnormalities, unspecified abnormalities in some lab test, that she, characteristics of domestic violence victims and so forth, is just of no moment. So it's irrelevant. It's commenting on the testimony of and the credibility and veracity of other witnesses. It's commenting on ultimate facts. If you want to talk about the expert portion of it, as the defense said, this is all the same things that Ferris is going to testify to. So in essence, I haven't heard his testimony, but what I understood was everything, I believe it was something along the lines of what she's going to testify to is the same as what Mr. Ferris is, and I only say Mr. because I don't know his professional designation. So Mr. Ferris is going to testify to. Finally, on the issue of 403, Ms. Sweet's testimony, the probative value of that is substantially outweighed by the danger of confusion of the issues and misleading of the jury, because it does not matter whether that particular person believes it was a violation of injunction or not. The point is, the testimony is out. It's been demonstrated that the defendant knew about that. She's alleged it was a violation of injunction. There's a dispute. That'll be a factual issue for the jury to determine. But she's alleged it was a violation, which she took as intimidating. And the smell that caused her headache was some sort of physical ailment that would have been caused by the present that was provided. I understand that's her position. State may have a different argument on all that. But this is not even a difficult question. Ms. Sweet is not is not admissible as a witness. I am glad you proffered, though, because now it's all on there. But no, she's not going to be allowed to testify to what I heard today. Do you have another witness we can call?
Yes, Ferris.
We have an objection to him as well, Judge. We filed those.
Oh, now, Mr. Ferris is the expert,
Yes.
and the state wanted to have a,
Judge, I'm sorry. We do have a lay witness that we want to get on. Amy Carlton, she's going to be quick. We need to get her back to work.
oh, hold on, Amy Carlton. And then I assume, I know that's bad, that Mr. Ferris, tell me, does he have a professional designation? Is he a doctor or?
He's a licensed mental health counselor.
So he's Mr. Ferris.
Former deputy sheriff. His practice and his law enforcement experience has been combined exclusively to domestic violence. He teaches batteries.
I just want to know if he was had he a professional designation that I should use? All right, so Mr. Ferris, looking at the time, I would think that after we finish with Ms. Carlton, the Daubert hearing is very likely going to take us to the end of the day. So I expect that we would probably start with Mr. Ferris on Monday. Mr. Taylor?
Well, Your Honor, actually, we have some case law that I was hoping would obviate the necessity for doubt.
All right, well, do you want to handle Ms. Carlton first?
Please.
All right.
Ms. O'Donnell just needed to go to the ladies' room, so.
Oh, all right.
If you want to bring them back in, that's fine. If you
Well,
want,
yeah, we can start working them back up.
yeah.
I think that'll be good. So let me give you guys 5 minutes.
Thank
If you need to step out, Mr. Taylor, Ms. Benefield, if you need to step out and use the facilities, that'll be fine as well. We're going to start working on getting the jury up. It usually takes about 5-10 minutes.
Yeah.
Thank you.
Thanks, Judge.
We're taking a walk.
Okay, bring him in. Oh, does anybody need the screen?
No.
No, sir.
Oh, and can we get the site for the case? Mr. Taylor, can we get the site for the case that you sent back?
I can do better than that. I can do
Perfect, thank you.
You can't. I think I know exactly which one you're bringing me. Bring me, though. All right, y'all can have a seat. I see the jackets and the sweaters have gone on. Yeah, you would think in the afternoon it would get warmer, but I told you, even with the southern exposure, somehow it just gets cooler and cooler and cooler. So, all right, while you were out, did anybody discuss the case amongst yourselves, talk about anything about the case, talk about anybody outside of the jury about the case, or do any research on people, places, things, or legal topics you've heard anything about? All right, everybody says no. Mr. Taylor, call your next witness.
Amy Carl.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, or right if you need it. And just speak in a loud, clear voice and we'll hear everything. Can I just move you just a little bit forward?
Okay.
That's perfect. Thank you. Yes, sir, Mr. Taylor.
Good afternoon. Would you tell us
Good
your
afternoon.
full name and state your last name, please? Spell your last name.
Spell my last name, C-A-R-L-T-O-N.
And your first name?
Okay.
Tell
I'm
us.
sorry,
What is your first name?
Amy with a Y.
Okay, Amy. Or Miss Carlton. Are you presently employed?
I'm presently employed, yes.
Yeah, where?
Where?
Where? For who?
I'm at one of the hotels in the area.
Okay. And what capacity do you serve in at the hotel?
I'm one of the managers.
How long you been doing that?
What was that?
How long you been doing that?
I've been with the ownership for 4 years now, going on 5.
Are you married?
Yes.
What's your husband's name?
Herbert.
Miss Carlton, were you and your husband Herbert living in Bradenton, Manatee County on September 30th, 2020?
Yes.
September 27th, 2020.
Yes, we were.
Do you recall that afternoon if you were outside with your husband?
Yes, we were.
Do you recall the address you lived at back then?
It was on Newport News Street or Drive. We've been renting, so to be honest with you, I don't recall the exact street, the number of the street, but it was Newport News.
Do you recall, Miss Carlton, whether or not, what was the reason why you and your husband were out that afternoon?
I have a mini golden doodle, and we were taking a walk.
Did anything unusual occur while you were out with your husband and the dog?
Reason I'm here, you know it. I mean,
Would you share it with us? What happened?
we were taking a walk, and Newport News is a couple streets over from the incident area, and it was probably 3 houses down where we were. And at the time, my dog was probably just over 1. So I don't know. I'm a big dog lover, and she's my life outside of work with my husband. He and I both heard what I don't know. I didn't know what it to be, and he kind of grabbed my arm, and I kind of got startled because it did sound like gunshots. I don't know. You know, at the time we didn't know what it was, and but we heard one right after the other. And me, because of where I work, I'm trained like the attack or panic mode. I am thinking of myself, sorry to be selfish, and my dog and my husband, and he's looking ahead too. And I just remember being a little bit terrified myself and thinking of myself, my family. And so I remember looking up and telling him, well, let's go, let's turn around, let's go back behind the house, because at the time we weren't sure what it was. And so being trained, you don't know what is to come next. First of all, you don't know what it is. So as I'm telling my husband, I told him, call 911. As I'm telling him that, I'm sorry, I'm backing back behind the house because you don't know what's coming next.
All right, let me ask you a couple of specific questions if I can.
Yes.
You say you heard some gunshots.
It sounded like gunshots.
All right. Now, after you heard the gunshots, did you observe anybody exit a house?
Quickly, as we were trying to make sure of our safety, we saw someone leave the house, a lady leave the house. It was, I mean, I don't know exactly, like timing wise, because it's like I said, my mind was going through a lot of things.
Let me just keep you on the questions, okay? I'll help you. I'll lead you through it. You hear the gunshots. The next thing you see is what?
A lady came from the house, and
Describe.
I remember screaming, and that's just the vivid recollection and memory that I have, just the screaming. And I came from the house running to the neighbor's house. I don't remember too much other than the screaming and pounding on the neighbor's front door.
Is it a safe bet for us to say that this lady that you saw exit the house screaming was hysterical?
Yes, yes.
I want you to tell us, Miss Carlton, after the gunshots, approximately how long it took for that woman to come running out of the house.
Oh, so I'm not sure I recall. It was within seconds, though. It was, I don't know. I mean, I didn't even have time, like I said, to pursue any hiding places. It was so quickly.
Do you remember speaking to the police about the incident?
We had an interview, yeah. It was probably 30 seconds, a minute. I don't know, 30 seconds.
Okay. So you hear the shots, and within 30 seconds, a screaming, hysterical woman comes running out of the house and goes to the neighbor's house.
Yes.
Did you hear banging on the door at the neighbor's house?
I don't recall if I remember stating that or not, but I remember the hysteria of the screaming.
Okay. That's all I have, Your Honor.
Can the witness be released?
Yes.
Yes.
Thank you, Ms. Carlton.
Thank you.
Ma'am, you've been released from your subpoena, so you're free to go. Thank you. Approach. There's the jury. So the attorneys and I need to talk about what's going to happen next week. We got to do some legal matters that are outside the province of the jury. So at this point, I'm going to let you go for the weekend. It's about 10 till 4, so you're free to go at this point. Remember the rules for the weekend. Please do not discuss the case amongst yourselves. Don't talk about it with anybody else outside of the jury. And certainly don't do any research on the people, places, things, or legal topics you've heard anything about. And that includes being very mindful of watching out for any media that may be on anywhere you go and wherever you might be, to avoid all of that. Listen, do you still have your parking passes?
Yes.
Everybody's got that. If you've lost your sticker, is there somebody downstairs in the jury room?
Yes.
Oh, you've got a bunch of them? It's like pads and everything. We got them everywhere. Great. So make sure you keep that parking pass. If something happens and you lose it, you're going to have to come in Monday, see the jury coordinator to get another one, and then go park, because they will give you a ticket or tow you, one or the other. All right. So thank you very much. It's been a great week. Yes, ma'am.
What time do you want us here Monday?
I always forget that part. We're going to start at 9 o'clock on Monday. So if you can be downstairs at 8:30, 8:45 is just fine. Listen, I will say this, though. Remember on this past Monday how there was a whole bunch of people? That's how it's going to be this coming Monday, because we're going to be picking another round. Other judges are going to be picking other rounds of juries. So you don't have to necessarily stick together, but you're probably going to want to be off a little bit. Unless you want to tell the other folks there how great jury duty is. That way they won't try and get out of it. All right. Great question. I'm sorry I forgot about that. Thank you very much. You are free to go for the weekend.
Thank you, sir.
Thank you. All right, you all can have a seat. I will tell you, I don't think I need to hear a whole lot more about Mr. Ferris. I think we've talked about it quite a bit. I'm ready for the hearing. I will say this: it is a hearing, so if you want to make an opening, don't feel like you can't. You're absolutely free to make an opening if you want, Mr. Taylor. So please don't let me dissuade you. If you want to make an opening, make an opening. State?
No, Judge.
Thank you.
I think
I do.
My name is Judge White. I'm presiding over the case. We're going to have a Dowry hearing. I'm sure you're familiar with that.
Yes, sir.
So just put yourself about 12 to 15 inches from that microphone. Make yourself comfortable in that chair, and we'll get started with the hearing.
All right.
Good afternoon.
Good afternoon.
Tell us your full name, please, and spell your last name.
Bruce Eric Ferris. The last name's Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor. I do individual therapy, and also I do consulting on domestic violence and expert witness testimony.
Let's discuss your education. Would you inform us, please?
Sure. I have a Bachelor of Science degree in civil engineering. I also graduated the local police academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
Do you have any specialized education or training in a specific field?
I do. If you look at my curriculum vitae, I think there's over 100 items listed where either classes or seminars or teachings and certificate training that I've attended.
And included in that, would domestic violence be a major part of it?
That was the definitely predominant theme of whether it be a specific class or a conference on domestic violence and intimate partner violence. And if you'd like, I can explain the difference.
Please.
Domestic violence has to do with what we might think of people have a child in common or family members, and that doesn't necessarily mean an intimate relationship. It could be two relatives living in the house together. Intimate partner means there's an intimate relationship, a spouse, a boyfriend, girlfriend, so there's a little difference there.
Try to make sure your voice in the microphone because it tails
Sure.
off.
Thank you.
Mr. Ferris, have you taught any courses or presentations in a specialized field?
I have.
Please enlighten us.
If you look at my CV, I've given, I think, over 40-some presentations and teachings. For 8 years, I taught a batter's intervention program class to offenders, uniquely that. And for anyone that doesn't know, batter's intervention is a program is for offenders. It's usually court-ordered, part of probation or part of a sentence or part of an injunction or a restraining order. It's a 6-month psychoeducational class. I've been trained for that and teach that. I used to teach Gardner Lightham volunteers about domestic violence and effects on children. I've taught the 8th Circuit staff, the state attorney's office about domestic violence and impact to women and children and batterers intervention, how to interview people. From 2008 to 2020, I taught at the University of Florida Law Clinic on intimate partner violence to law students about the same type of subject, domestic violence and intimate partner violence and effects, and also enforcement of the law. I also trained police officers about domestic violence enforcement. Currently, since 2009, I've been teaching officers how to de-escalate confrontations as part of the crisis intervention training team. I teach the de-escalation part of that. There's a lot more I could talk about, but that's the nature, and you could see in my CV.
All right, let's talk about your work experience.
So I have an affiliation with Village Counseling Center, doing therapy, DCF cases, and domestic violence related cases. I used to also work with Creative Counseling in Gainesville, teaching batterers intervention program classes and doing individual therapy. I also have my own practice now, and I do individual counseling. Recently, I just looked up, since 2014, I've treated almost 1,000 individual clients or patients as an individual therapist. Work experience we're still talking about. Of course, I mentioned doing consulting for attorneys on domestic violence and being an expert witness. You want to know my current work or my past work?
Well, let's stay in the past. How about the experience with the Gainesville, Florida Police Department?
Yes, I went through the police academy in 1993. I was sworn in 1994. I retired from there in 2013. The last 10 years of my career there, I was the lead detective in the domestic violence unit, part of the Investigations Bureau, uniquely just looking at domestic violence cases, enforcing the law, training officers, doing some public outreach, and being on various task forces.
Can you give us an idea over the course of that time, approximately how many cases you would have handled?
I was a lead detective on close to at least 500 cases I looked up were resulting in arrest or charges being filed.
And what kind of professional credentials do you hold?
I'm a licensed mental health counselor in the state of Florida. I have certification to teach batterers intervention program classes through the state. I also received certificates to do threat assessments, domestic violence threat assessments through Jackie Campbell at Johns Hopkins University. Also trained in doing counseling and work with adoptions through Rutgers University.
Have you been the recipient of various awards and recognitions?
Yes, I have. I was chosen by the Alachua Board of Commissioners to be commended to Governor DeSantis to be on the Alachua County Child Fund, Tax Fund, I guess they call it, Trust Fund, excuse me. I've also received various awards for my domestic violence work through the local shelter. I received a statewide award from Attorney General Pam Bondi and Governor Scott at the time for my work. In 2010, I was awarded and recognized for my work with victims of crimes in the state. There's several other ones. Without looking at my CV, I don't recall them all.
Sure.
I received some recognition of contributions for the work I did with that CIT team. University of Florida also gave me recognition for training that I'd done with their officers. I was Big Brother of the Year, and for my work with my little brother for about 10 years, I worked with a little kid as my friend. And I was also the Law Enforcement Officer of the Year as granted by the Domestic Violence Abuse Network in Gainesville.
Are you a member, Mr. Ferris, of any specialty boards, committees, or professional organizations?
Again, lying a little bit on my CV because of the nature of the question.
That's fine.
So in 2022 to 2024, I was a member of the Rape Crisis Center Advisory Council. I was a member of the American Mental Health Counselors Association, retired member of the Fraternal Order of Police. I was a member of the 8th Judicial Circuit, Florida, a Family Law Advisory Group, a member of the Gainesville Domestic Violence Task Force. I was a member of the 8th Judicial Circuit of Florida Domestic Violence Fatality Review Team. I was a board member of the Gainesville Commission on the Status of Women, a member of the Alachua County High Risk Domestic Violence Team. I got some recognition for my work as a volunteer with University of Florida College of Medicine. I was doing mobile outreach part-time as a volunteer. I was a member of the University of Florida Male Leadership Committee, again dealing with domestic violence. I was also on the planning committee for the Sexual Battery Conference in Gainesville for many years. I was a member of the Gainesville Mental Health Consortium, United Way Community-Wide Strategic Planning Safety Committee. I was part of the working group for leader for domestic violence coordinated community response for local law enforcement and best practices procedure. And I was a member of the statewide domestic violence needs assessment group organized by the Office of State Courts and Office of Court Improvements.
Have you been recognized as an expert by courts in the state of Florida, an expert in domestic violence?
Yes, just as a footnote, I've been recognized as an expert in domestic violence, in batterers intervention program class, effects of domestic violence on children, and generalized mental health work. I've been involved with about 60 cases, consulting or testifying. Not all of those did I testify. I did testify in over 50 of those cases.
Both civil and criminal?
Yes, both civil and criminal. Majority were in civil, the types of working both for the defense and the prosecutor, state attorney's office, but the majority were civil.
All right. Would you be kind enough to educate us a little bit? What is domestic violence?
Domestic violence, domestic violence, according to Florida state criminal law, is acts of battery and assault, ag battery, ag assault, false imprisonment, sexual battery, all these different person crimes from one family or household member to another family or household member. So that now the definition is what's a family or household member, and that's people that are married, living together, maybe had a child together but have never lived together. People living together as a family in a house. It doesn't include, let's say, cousins that never lived together. So it's unique in that way.
And is there another definition of domestic violence?
Yes, and in my practice and in my training, this is a pretty accepted concept that domestic violence is actually a pattern of power and control. And the key word here is pattern, that's repetitive. And the criminal definitions, the physical things, those are used by perpetrators or abusers to control their victims. But along with that also is used control tactics. We often think about emotional abuse or those sorts of things, and they're defined in the Duluth Power and Control Wheel.
Would you explain to us what the Duluth Power and Control Wheel is?
So the Duluth Power and Control Wheel developed up in Duluth, Minnesota by a group of researchers who deal with domestic violence. And what they did is they looked specifically at domestic violence cases, that of criminal cases, that victims who came through shelters, DV shelters, and they were looking for what were the tendencies or the tactics used by abusers against their victims. And they developed this power and control wheel. It's used around the country. It's the Duluth Power and Control Wheel is the basis for the Batterers Intervention Program class I mentioned. DCF, Department of Children and Families, has accepted that as a reality, a fact, and that was the criteria or the curriculum for the BIP class used statewide and actually used around the country and internationally. So there's these 8 inner items, and on the outside of the depiction, I don't know if...
All right, let's see if, Judge, with the court's permission, we put the screen down.
Probably a little bit so we can see. That's perfect. Thank you.
Judge, may I ask you a question? Could I stand over here?
Sure.
Rather than try to do it for you.
Reposition as you need. It's just us.
Okay, thank you. It's just a little easier to see this way for me.
Absolutely.
Thank you, Judge.
Oh, but though, the only thing is you can't be so far that the court reporter can't hear you. And she's listening to these microphones. So why don't you turn that, and then if you just position so you're facing there.
Hear me okay?
There
Can
we
you
go.
hear me now?
Yes.
So you can see that.
I was going to say, let's get you a
Sure.
little closer.
Thank you, Judge. Thanks for reminding me. So this is the Duluth, as I said, if you look here, Domestic Abuse Intervention Project. This was established some, I don't know, maybe 30 some years ago, 30, 40 years ago. And this is the standard used around the country and used for the Batter's Intervention Program class and in a lot of counseling I do. And this is part of the counseling along with cognitive behavioral therapy is one of the therapies I've been trained in graduate school and my work. So on the outside here of domestic violence is physical violence and sexual violence. And that's covered in the state statutes, the criminal law statutes. Then there's these 8 items that are part of the power and control. And remember, I said it's a pattern of power and control. So that means it's repetitive, it's a way for the abuser to get their victim to comply, to get into a compliance mode. I'll talk about that in a moment. So the first item is using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons. I run into this all the time in terms of using intimidation. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy. It's very common. Playing mind games, humiliating her, making her feel guilty. Using isolation, controlling what she does, where she goes, who she sees. Oftentimes spying on their victim, checking their phones, tracking them, etc. Minimizing, denying, and blaming. I find this in almost all the cases I work. They make light of the abuse, say it didn't happen. They shift responsibility. It didn't happen, it wasn't that bad. It was your fault. So minimizing, denying, blaming. Using children, sometimes put their victim, the mom, in fear of what he'll do to the child or that he'll report her, etc., that she might lose the child. Male privilege, this has to do with the role that he makes the decisions in the family or in the relationship and gives her a specific role. Economic abuse, and this would maybe be preventing her from having a job or money, or she should have an allowance, etc. And then the last item is using coercion and threats, I'm just having problems reading the fuzz here a little bit, making and carrying out threats against her, threaten her, using coercion and threats. So I'm going to sit here, that can stay up, and I'm going to make a few comments about it. So the main issue here that, as we understand the power and control wheel, is these are techniques that the abuser uses to control their victim. And like we say, it's a pattern. So that means it's repetitive. And so what's the purpose of that? It's to get them to comply. And so the victim ends up trying to avoid the perceived danger that they'll experience if the abuser perceives that they're opposing them. It's particularly true for mothers that are, not only are they trying to protect themselves, but they're protecting their children. And I found that there's victims of domestic violence tend to get into what I call equilibrium stasis experience. In other words, they avoid the perceived threat, so the proverbial, the old phrase of walking on eggshells. So they end up being in this compliance. They don't want to poke the bear, so to speak. So they find this narrow way of coping by going along with the perpetrator and don't want to make him angry at them, because that's when the violence occurs, or the threats, or the emotional, the hardship. And that's exactly what the perpetrator, the abuser, wants to happen. He wants to keep her in line, so usually to manipulate, to get her to do what he wants to do, that they feel a sense of ownership, and they use these techniques to control. They also, the victim wants to appear to be going along. They don't want to anger him. They'll actively hide that abuse from family and society, because if it gets out, he's going to be mad. I could speak certainly a lot more about that.
Are there, Mr. Ferris, common characteristics that abusers share?
Yes, they could be anyone from any socioeconomic group. I've been involved as a therapist and as a detective enforcing the law with all types of society and sexual orientation, from wealthy, well-known NASA scientists, doctors as a perpetrator, to the homeless person and everyone in between. And in Gainesville, where I worked, we have a great population from all around the world there. And I didn't find a difference other than sometimes attitude, but every socioeconomic group, it's very, and also tend to be males, but females also. Just yesterday, I took on a new client, spoke to him. His wife's in jail. He has 4 children with her, and he's a victim. So he's a victim. So there's female abusers and male abusers. Males are predominant. I know when I was working, I ran some statistics on cases, and I found it was about over 2/3 of my cases were male, and less than 1/3 were females. And some of those, and that reflected also when people would want to debate that issue about men or women. One thing that always struck me is when you look at fatalities, the statistics are about the same. There's usually the murderers are mostly men by about 2/3 over the women. So the actual victimization cases and then the actual fatality cases, statistics I found ran together.
And what do they have in common?
Usually that they want to control their partners. There's an ownership attitude. They use the power and control techniques I described to do that. I also find that they're missing true empathy. I've kind of named it to myself is they're missing an empathy gene. And empathy has to do with the ability to feel someone else's feelings. And I find many of the perpetrators that I've counseled and also worked with in the BIP class, and certainly in my police career, they tend to be very selfish, a lot of narcissistic sort of ideas. Image it as many of them, not 100%, but a majority. It's kind of like their point of view is, I'm here, and everyone and everything around me relates to me. I'm the center of the universe, as opposed to a healthy relationship where there's an equality. I'm being thoughtful and considerate of my wife as she is for me, and there's some balance. They don't necessarily adhere to that. They disguise how they treat their victims. Usually they don't want to let other people know about that, much like the isolation element. They want to keep it. And there's reasons for that. And some of it has to do, they don't want to go to jail if it gets out. And then they don't want, I found this a lot, that perpetrators don't want their victims to get the idea that they're not a good deal, that there's something they're doing that's wrong, so they isolate them from society as such. And they'll put on a real front. I have numerous cases like this, how they disguise, how they treat their victims. There can be the perpetrators, can oftentimes be very appealing, and they're very good at convincing people of things. I found a certain finesse amongst those thousands of BIP clients I had, that there were some very good talkers. I'll just leave it like that. But emotional and physical abuse is certainly what we think of. I've certainly worked a lot of cases where there was broken bones and bruises, etc., and emotional abuse and isolation and coercion threats, etc. But many of the cases I see, there isn't acute violence. It's emotional abuse. It's these techniques The question is, can the abuser convince the victim that they're in, and put them in fear so they adhere to what they say? If they can create the fear, as one lady told me, she was in fear of him so much, they would be in a public place and they're separated and they're across the room. And if he saw her talking to a male, he looked at her and she knew right away, end the conversation, move on. There was a fear. And there was no violence in that relationship, but she was scared of him. Also, as we know, as Judge knows, and Mr. Teller, the ASA knows, battery, in the state of Florida, there's assault and there's battery. Battery is the unwanted touching, that's the hitting, the punching, etc. But assault is also a crime. That's being in proximity to someone, showing a threat. I'm bowing up, have my fists up, and the victim has a perception that the violence is going to occur. That's a crime, though there's no marks, there's no scar, there's no hitting, but there's fear. And so sometimes there's assaults that are taking place that aren't reported. And if on top of that, if they can create that fear to go along, that's a common technique that I see happening. It's all about keeping control, their victim. And one real common thing that I've seen is obsessive jealousy. And when I worked with batterers, I was surprised, and I came to learn very quickly that they oftentimes equate jealousy with love. And we all know jealousy can be very detrimental to the object of the jealousy, and also to the person having the jealousy, being obsessed and worried, etc. Love, we all know, is something else, completely different, very kind, considerate, and very empathetic, very different, but they didn't understand that dynamic.
Let me ask you, Mr. Ferris, do they exhibit, with respect to these characteristics in common, what is their behavior relative to animals, pets in particular?
So understand, so cats, dogs, etc. So there's above average abuse of pets by domestic violence abusers. So I have two explanations for that. One is what I talked about, their missing empathy, that they don't feel for a dog or a cat like I might feel. I'm very empathetic. I am in love with Rosie, my poodle. So is my wife. So that means a lot to me. But to an abuser who doesn't have empathy, it's not a big deal for them. They see it as an object. That's one thing. The more important item, especially in terms of power and control, has to do with that. It gets back to the controlling of their victim. If that victim is attached to that pet and I abuse that pet, now I'm putting you in fear for what I'm doing because I'm hurting your animal. So I'll attack that pet as a way to control you. You better not oppose me again, or you better not leave, or you better not go out with your girlfriends when I say you shouldn't, or I'm going to hurt your pet. I'm going to kill your pet even. So it becomes part of the continuum of power and control. And the sad part is I've also found that many perpetrators have that same mentality they use against the female's children, in the sense that the women are highly protective of the children. And so he's using the child as a way to gain control over the female.
And what about the abused, Mr. Ferris? Do they have common characteristics as well?
Yes, the majority are female, though, like I say, I treat male victims of domestic violence also. I'm still kind of surprised at times when I meet a new victim for the first time. And remember, for 13 years, I've been getting clients from our local DV shelter as a consultant and a therapist working. So I get constant feed of them. And then I also have my other sources and attorneys, and just my people know who I am, so they come to me if they're victims. But I'm always amazed at how many don't truly know what domestic violence is. And even I've had I've had clients who don't think they're a victim of domestic violence. They'll know there's a marriage problem, but they haven't I'm refraining from being too graphic because I've seen it all in terms of broken bones and types of violence in families. So they haven't been violently attacked and hit with the 2x4 or something. But I go over the power and control wheel, and they say, holy cow, this is my life. This is what's been going on with me. I remember one crime scene I was at, and the woman had been a victim of domestic violence, and she wouldn't talk to us. And I had a moment to speak to her, and I showed her the power control wheel and had a moment. There's a victim advocate there too, and we went over it, and all of a sudden it was like a aha moment, and she goes, darn. And I think it was a strangulation case, and she realized, and I've had some specialty training and some certification about being an expert in strangulation with the state, another subject, but she realized that she came within 4 minutes of dying for lack of oxygen to her brain, and once she realized the power and control wheel and how dangerous it was, she opened up and shared information, and that suspect who had left was eventually found. So also statistics show that domestic violence victims will leave, on the average, about 8 times they'll leave their perpetrator before they finally leave. It often happens. And there's also socioeconomic and ethnic groups that have unique attitudes to domestic violence. This idea of protecting a child for the mother as a characteristic is very, very significant. I guess I'll take a short moment. There was a particular case that comes to mind. This mother was very abused by her husband, and he made her stay.
I'm going to object. We've just gotten into a narrative. I think he's established this fact.
Sustained. To the narrative.
Okay, so you want me to skip the story? Sure.
All right. Describe what coercive control in a relationship means.
Coercive control are acts of assault, threats, humiliation. You're trying to create harm, punishment to frighten the victim, much in the manner that we're talking about a pattern of power and control. By creating fear, it's all working towards controlling the victim. Of course, like I say, the power and control wheel is the tactics, along with physical violence and sexual violence. And then we get into that appeasement or compliance that I've talked about. They want to avoid the pain of the conflict. Pain can be emotional pain. I've had women tell me, I rather get slapped upside the head, excuse me for the phrase, but then be told I'm ugly or fat, or my self-esteem totally crumbled. And so don't underestimate how important emotional control is in that sense.
Do these offenders always behave violently, or does abusive behavior happen in cycles?
No, as I've explained, it's not always violence. It's perceived violence in terms of the threats are enough to create fear in a victim that because of some assaults or in using intimidation, making her afraid by looks, actions, gestures, smashing things, destroying property, displaying weapons. These are all acts of intimidation that affects them and can create a great fear because of the narrative they project, the reality that they're living as the victim, and they get into this compliance mode and be very dangerous. There is, in terms of cycles, in the industry, I'll call it, you recognize there can be kind of this rain, sunshine sort of model, that there's acute abuse, and that's kind of symbolic of it raining. And then the sun comes out, and there's a honeymoon phase with couples, and the sun, everything's nice, there's no violence or no emotional abuse, and then all that rain with the hot sun, clouds form again. And then the clouds are too heavy to carry the rain, and then it rains again. So there's in some relationships, not all, but there's this cycle of violence or emotional abuse, and then a honeymoon. There's also a generational cycle that I'm aware of, that you grow up in a family where roles are very defined. The male is the head of the household, the wife doesn't oppose him. So sometimes that cycle goes, I see it in my clients from generation to generation until it can get somehow, someone breaks free from that, and maybe that male realizes that's not the best role to have, and a female realizes, I don't deserve this, and they move on. So that's another cycle.
Does the victim, Mr. Ferris, always appear to be afraid or act like they are afraid of the offender?
Definitely not. This gets back to what I've already been talking about. They're hiding that fear from friends, families, and for good reason, in the sense of the consequences of laying it out. Then they may not understand all what's going on with domestic violence, but sometimes I've had victims say that they deserved it, that they caused the violence, that they didn't keep the house clean enough. They've got almost a brainwashing going on about what's expected of them as a woman. And they found this, I'll call it a dissociation from the facts, a mental health term, an avoidance that allows them to comply because of their fear. And so it becomes, so no, they don't always appear to be afraid.
Let me ask you this. How common is it for the victims to smile and act happy?
Got far afield from what needs to be established on her daughter. As far as domestic violence, I'll stipulate he has this knowledge as to domestic violence at this point, but I think we've gotten far afield of what needs to be established.
Judge, I might recall for the court that they played the video of them all in the restaurant.
I'm not sustaining. I mean, this is your proffer, so
Thank you.
You tell me what you want me to know about your expert, and I'll decide what he can say and not at
Thank
trial.
you. Would you elaborate on how common it is for the victim to smile and act happy?
Very common. And it speaks to what I've already been discussing, that they try to hide the abuse from others sometimes for personal reasons. They don't want him to get in trouble. I've had mothers that are financially dependent, and they don't want him to go to jail or prison, because how will they take care of their kids? So they sacrifice themselves. They are afraid of what society is going to say, or they're afraid of the abuser. So especially the afraid of the abuser is a really big part, and that they stay in line. And again, it speaks to this idea of compliance, or equilibrium, as I call it, find the lowest resistance to survive. And so they get into survival mode, and that walking on eggshells. And as a therapist, when victims come to me, we've got to untangle this stress and trauma and come to terms with that, because they've gotten this lifestyle, compliance, and all the hurt that comes with that, and how their self-esteem's been damaged. I could go on and on with that subject.
All right, so tell us a bit, if you would, Mr. Ferris, the role that appeasement plays in domestic violence.
It plays a huge role. We could say appeasement, we could call it compliance, we could call it walking on eggshells, we could call it don't poke the bear, get along. It's all about avoiding pain. And that's the very technique, the fear, I'll use fear as equivalent to pain, that is a way to control, hence why this is called the power and control wheel. These are techniques, along with physical violence, that are used to control their victim and get them. And there's an ownership, I've already mentioned, a certain ownership, the jealousy, etc. And also I found some of my abusers become obsessed with their partner, that ownership quality at all costs, and they're just highly obsessed, and it can get very dangerous, actually. I've worked cases where there's been homicide, that if I can't have you, nobody can have you. And if a victim realizes that their perpetrator's capable of hurting them, they're going to go along, or they're going to get on a jet and fly somewhere real far away.
All right, tell us, if you would, what the impact of a child has on these dynamics.
So the impact to the child, or having a child in the scenario?
Having a child in the mix.
A huge impact. I've found women who certainly want to protect themselves and do this compliance, but when there's a child involved, and if they have a strong maternal instinct, they're going to sacrifice themselves to stay in a relationship. I've worked many cases, to my surprise, where there was no reporting of the violence or domestic abuse occurring. And so the woman, the mother, wouldn't seek a divorce because they knew, typically in our state, if there's no extreme reason, criminal history, drug history, violence, etc., it's going to be a 50-50 custody. So I've had women who have stayed in the relationship, taking the abuse, because she's so concerned that she wouldn't want her child to be alone with that perpetrator. She sees him as a brute or a bad role model, etc.
And might that type of a scenario play out with the woman acting happy in an effort to go along and be in the company of the abuser to protect her child?
Without a doubt, that's the whole scenario. And there are women that are better at it, more sophisticated at it than others. I'm just finished working a case where her family, as I interviewed, I won't make this long, but there was abuse, he's in prison, she was pregnant, she gave birth while he's in prison, she stayed with him. A couple years later, he was running his business while he's in prison. She finds out he's getting out early in 3 months. She commits suicide. She hangs herself because she was so afraid of him coming back. Her maternal grandparents had the child. I'm working on that custody issue and the criminal case. But the point I'm making is that when I interviewed the parents, the sister, the friends, all these people before the suicide occurred, they didn't know how bad the relationship was. She wouldn't show up to family gatherings, or she'd come and go, or they wouldn't see him. She was totally hiding all that extreme abuse that she was going through. The family didn't know about it till the end, before he was charged and went to jail. So she went to great lengths to hide because she was scared of him. And I believe her going along with him and running the business was all out of fear also. And then she couldn't face it and decided to leave us.
A few questions, if I can, as it relates to domestic violence abusers. What have you found in your experience and education as it relates to their ability to charm and deceive others?
Yes, I found this in a majority of the cases. They want to project an image, again, hide the abuse. Sometimes that's their strategy to deceive others because they don't want to be found out. Also, I might add that the recidivism rate, when I was running the BIP classes, I was always surprised I'm getting the same guy back again, that there's a personality issue here that hasn't been solved per se with some men, and that there's a tendency to abuse over and over.
Is there a unique pattern of denying, rationalizing, minimizing, or blaming the victim that's typical?
It's not only typical, it's in a majority of the cases that I've ever worked. I see this almost in all the cases, I'll say. And if we look at the Duluth Power and Control wheel, there's actually, at 5 o'clock, minimizing, denying, and blaming. It didn't happen. It wasn't that bad. It was her fault, which, as I've explained in the past. So that's very typical. It's also a form of gaslighting that's been in, I think, the news the last 10 years. It's a form of control and gaslighting a victim.
Does it include suggesting that the problem stems from the victim's mental health problems?
Definitely. That's a very common theme. It's also gaslighting, and also it's in the power and control wheel using emotional abuse. About the third line down, making her think she's crazy. So it's a destabilizing technique. If you've got so much influence over me that you convince me that I'm crazy, then maybe it didn't happen. Maybe I'm wrong. So it's a self-esteem killer.
Give us an idea, if you would, of the barriers that exist to these women leaving the abusers.
Fear of being harmed, certainly. If they report to victims, barriers to leaving can be, as I mentioned, cultural upbringings or norms, roles. A lot of victims are financially dependent upon their perpetrators and don't know what else to do, and they don't necessarily have any other resources. Sometimes when I do trainings, I confront my audience, especially when I've got law enforcement or victim advocates, about their expectations of victims leaving that perpetrator. You expect her to walk out on the street with 4 kids and she doesn't have a credit card and no family. And I could go into this a little deeper. I'll avoid doing that now. The fear of losing her children. So sometimes victims have experience with DCF. They understand what can be consequences if it's reported to DCF. So they don't want to report, because I've been party to this in a lot of cases and termination of parental rights cases I've been involved with, that if she's staying with the abuser and a child, and I mentioned I taught a class for DCF to fathers and mothers, and also trained on this a lot, that exposure to a child to trauma is trauma to that children. Separate from the traditional child abuse that we think of hitting the child or not changing the child's diaper, not having food, but actually subjecting the child to the yelling, the screaming, the abuse is trauma to that child. So if a female doesn't report and she's found out, then that can be considered a failure to protect. Now all of a sudden, and she's still a bona fide victim. So now she's being held accountable. Her children might be removed. She's got to go see people like Bruce Ferris for counseling. She's got to do all these classes. So and many know this, so they don't want that to be out and about. Also, sometimes I've had women, they still love him. They see the good in him. They feel he didn't have a good childhood, or it doesn't happen often, or maybe I created the problem.
So these aren't split-second decisions?
What specifically?
Do they vacillate sometimes when children are involved?
No.
Should I leave? Should I stay?
I like to think of it as an evolution to leaving, but what's the motivation? If you're in that isolated situation of just he's your world, where's the education? Where's the involvement? That's what the role of a lot of our domestic violence shelters are in outreach, and is to involve and educate. And yes, here's services you can have. Here's someplace you can safely go. But that denial that violence will happen again is not uncommon. That feeling that it was her fault. Religious reasons. I'm always kind of surprised that, and I mean no ill towards any religious group. I don't mean to say that, but I found sometimes ministers or churches very concerned about marriages or not getting divorced, and they actually recommend or counsel people to stay together that are hurting each other. And so that's an issue. This idea that he will hurt her if she leaves. In this quote, I'd rather see you dead than with someone else, is not uncommon. And also the total power and control continuum and the use of that to control their partners.
Is there a particular time in these kinds of abusive relationships when violence is most likely?
Definitely. The most violent time is when she goes to leave and he knows about it, or he's there.
In other words, when he forms the perception, that realization sets in that this is the end?
When she eventually puts her foot down and makes that clear, and I know from my certifications doing fatality reviews with Johns Hopkins University, that's in the danger assessments, there's a high probability of fatalities or extreme bodily harm at that time. It's very dangerous. When we do many shelters and victim advocates that might be affiliated with the state attorney's office or wherever, they try to establish a safety plan with victims. And that plan will include, when you leave, it's when he's not home. Don't do it when he's home. And also have a safe, unknown location to go to. I have many stories I could tell of women being hunted down and actually killed because of he knew where they were. And that just the trauma of that, I don't, even though I work in this field and I've been doing it for 20 years, it's hard for me to conceive that cloud over me of being subjected to being violently hurt. And if I am, who's going to raise my child? And will he hurt my child also? It's overwhelming for those victims. And I certainly see that in my practice, my counseling practice.
So let me ask you this as we close. Given your education and experience as a law enforcement officer, tell me, is there a general bias against females by males?
I think there is. Some of it's different social, ethnic groups, different cultures. Like I think I mentioned earlier, ownership of women. I've had, without mentioning the countries, I've been in say, Gainesville is a little stewing pot of people from all over the world. I've run into men who actually thought it was okay to abuse their wife because they thought she belonged to him. And I said, sir, this is America. That's not how it works. So this ownership can be cultural. It can be dictated by social norms, what their parents did. Certainly the media and entertainment plays a big part towards women and male roles in our society.
And where can this bias be found? Everywhere
in society, including institutions.
And would those institutions include law enforcement?
Law enforcement, and of course I worked in law enforcement, and I was always surprised at how I constantly had to, I actually became a little internal affairs detective for my officers who didn't understand domestic violence and had biases. And I was always surprised of the biases and found sometimes they were personal. An officer's going through a divorce, so all of a sudden he's at a crime scene and he treats the female badly because of his own world, not enforcing the law appropriately. But yes, it can be not, and also not everyone reacts the same way as a victim to domestic violence, and especially with other people. Some people have developed a very fat affect. In other words, they don't show emotion, and that's their coping skill. They actually shut down. They do this dissociative sort of thing. Other people become hysterical and exaggerated in describing. So every person is different. Just because you...
All right. Lastly, do uninformed professionals, in your experience, cops, judges, lawyers, counselors, often fail to recognize the signs of domestic violence?
They do, and sometimes it's because they're not obvious and they're hidden, or they don't understand the dynamic of domestic violence, and they don't necessarily understand that that victim was in fear. And though it may not show, they may be smiling in a photo, or their family or someone doesn't know about it. That doesn't necessarily speak to what was going on.
All right. Now, would you be able to relate these principles to the facts of a domestic violence case with any kind of reliability?
100%.
Have you done that before?
Routinely.
Is that what you in fact do as a professional?
It's one of the major things I do. I might put as a footnote, I'm a therapist. So sometimes clients come to me and I'm helping them with their anxiety and their depression and generalized mental health issues. But many of my clients, because I focus on domestic violence, I'm helping them understand, or the perpetrators, I'm helping them change their attitudes, usually through what I call cognitive behavioral therapy, and I could go on and on.
All right. Could you make that application and its reliability by studying the facts and documents relative to a particular case?
Actually, this is one of my professions.
All right.
I'm hired by the state for cases doing domestic violence assessments, and sometimes I never get to interview some of the parties. Maybe they're not available, they're in prison, it's in private practice, and also, like I say, through DCF, I've been hired. So I look at the characteristics, what fits, what was there a display of a weapon, was there all these different things, and
would you be able to do the same application with the same reliability through a series of hypothetical questions?
Certainly.
All right.
And if I can, I would admit that I can't.
Yep. Finally, let's talk about battered spouse syndrome for a moment. Are there any characteristics in traditional battered spouse syndrome that might distinguish it from an otherwise domestic violence abusive situation?
Good question. So basically, the abuse is the same. I think what makes battered spouse syndrome or battered wife syndrome, different terms through the years, different is oftentimes the victim still lives with the abuser, and there can be a history of extreme violence or violence occurring and traumatizing the victim. But the techniques of power and control and compliance and fear and how they hide it and all those things are completely the same.
Thank you very much. I have no further questions.
Ross?
Good afternoon, sir.
Good afternoon.
Have you ever testified as an expert on battered spouse syndrome?
No, I have not.
Do you consider yourself an expert on battered spouse syndrome?
I consider myself an expert on domestic violence, not necessarily the BSS uniquely. I haven't been recognized by a judge in that, doing that. So I think that for me, there's really no difference other than that distinguishing fact, whether they live there or not, or whether there's been physical violence or not. It's still the same dynamic. The victims are the same.
You could recognize the law might make a distinction between those two things,
I
an
can.
expertise in those two things.
Well, I think I'm expert enough to understand that. I just haven't testified uniquely in BSS.
And did you speak to Miss Benefield?
I did speak to her.
And for how long?
I spoke to her multiple times with a Zoom call.
Okay, my question was how long? How much time did you spend speaking to her?
It varied a little bit per hour. Most of the times it was 2 hours.
Okay, I need you to add it up. Did you speak to her 1 hour total, 3 hours total?
Oh, total time?
Yes, sir. I'm sorry if my question wasn't clear.
Going just by memory, I'd be guessing a little bit here, so I apologize. Could have been, I'm just trying to, could have been 15 to 20 hours easily.
So you spent 15 to 20 hours speaking to Miss Benefield?
I did.
Okay. And did you review paperwork in this case?
A lot. That's how I came to my conclusions, uniquely from the paperwork.
When you say uniquely from the paperwork, are you telling this court that you spent 15 to 20 hours with Miss Benefield, but you didn't base the opinions that you gave previously in a depot on that time?
That's true. I did not do an assessment of her. I was not hired to do an assessment. I did not produce an assessment.
Well, what were you doing for 15 to 20 hours?
Some of it was being a counselor, and some of it was I have a reputation to keep, and I wanted to understand was this really a victim? So kind of got into a routine of understanding some timeline with her about what occurred and how did it fit the facts that I was reading about.
Well, wouldn't that say, if what you just said is you needed to determine if she was a real victim, then it must have come into your decision-making about this case, with that assessment you made. Is that correct?
Could you restate the question,
Well,
please?
you just testified that you spent 15 to 20 hours in Miss Benefield, and part of that was to make an assessment on whether or not she was a real victim. And
No,
so,
not to make an assessment, as I compared the facts that I knew from what I was reading, I wanted some validity, and then some of my time was being empathetic and listening to her. But my conclusions I've come to that I talk about in the deposition were 100% from the discovery. Those were the items, and I could list them for you if you'd like.
did they include the stand your ground motion filed by Mr. Taylor and the defendant?
At the time, that was one of the items. Certainly, if I subtract that from what the things he quotes in the stand your ground were other discovery items. Doug admitting to shooting the gun into the ceiling, telling that to his priest, and phone calls and texts. So I didn't need the stand your ground paperwork document to find all those bits of information that I found through looking at discovery.
Well, so the portions of the Stand Your Ground about what happened that night were not in discovery. That Mr. Benefield took a bladed stance and did this.
No, I didn't. Those items were not part of my conclusion. I could tell you I have 13 items I use uniquely in discovery that it came to my conclusion on. And it didn't include, and I never spoke to Ms. Benefield about what you just said about bladed stance. I never talked to her about that.
Well, you said you spoke to her to determine if she was I guess to determine her veracity. Is that what you're trying to say?
That's one word, but I never spoke to her about the event of the shooting. Never.
Okay. Did you speak to her about the other things that were in the Stand Your Ground hearing and the discovery from things that had occurred in the past?
I think some of the things did, yes. As I think about, as she's going, basically I did some timeline understanding, when they met up until before the event, and some of those items were in there.
And did you develop an opinion as to whether or not Ms. Benefield was a battered spouse? Like, as far as battered spouse syndrome, if you would say that she suffered from battered spouse syndrome.
Yeah, I did not determine that. I determined that she was a victim of domestic violence and that Doug was the perpetrator of that.
Based on
all the discovery and how it fits in with the continuum of power and control and her compliance, her fear, etc.
Everything else, Judge, thanks.
Thank you, sir.
Tell us what you reviewed.
I reviewed a deposition that Doug gave, and I had a written version. He makes admissions. He talks about the gunshot. He talks about punching the dog, throwing the gun, punching holes in the wall. There was a letter to his pastor where Doug admits punching a hole in the wall and shooting the gun in the ceiling. There was a domestic violence injunction in South Carolina prohibiting mutual contact, and the text of that. A really important piece of evidence for me was Ashley wrote a letter on September 18th, 2017, when she separated, outlining domestic violence that Doug did to her. I have a copy of that if you want me to go through the items, but she outlines, without necessarily being a domestic violence counselor at all, she talks, it all fits very discreetly into what power and control and what abused women experience at the hands of their abusers. It was, and also for me, if I might say, that was a frozen moment in time. That wasn't something that she said after I met her or something like that. This was from, 2017.
And were you struck by the terms of basically art that she unwittingly included in that letter as it relates to domestic violence and the power and control continuum?
It was, it's a letter that I can use in training other people to counsel domestic violence victims, or if I was to work with a group of batterers, etc. It's classic.
Okay, what else did you review?
Deposition of a neighbor who caught Doug at night in the yard. A text of Doug admitting to putting a tracker on Ashley's car. I mean, these are all items that show ownership, that, stalking sort of items. A text from his ex-wife documenting him physically abusing her on her honeymoon. So this gets into his character, and
The question was, what did you review, not his opinion about them.
That's fine. Go ahead. Overruled.
Thank you, Judge. Go ahead.
So here I have all this experience dealing with perpetrators, being a perpetrator to multiple victims. Sometimes when I was a detective, I would, besides my therapy work, and I see that as I interview victims, but quite often my routine, I work day shift. So I come into the department, I go to a detective briefing, I look at cases where the suspect got away. My job was to review probable cause, go make the arrest, or get the warrant. That's what I did. So the first thing I do is I run that perpetrator's name, and I find out there's an injunction, and I'm looking at the charging document that the officer left, and there's no violation of injunction in there. But then I open it up in the court system, and I found it's a different victim. So I found there's multiple victims. And also, to be fair, I'd open up her, the victim's information, and I would find that there's an injunction, but it was with a different guy. So there's some serial victims, some serial offenders. So basically, the fact that he is very strong, and I know we talked about it in my deposition with the assistant state attorney. This text message from his ex-wife documenting how he abused her on a honeymoon was appalling to me, but it was not an unknown probability, and also it spoke to who am I looking at here. So that was one item. If I could continue. Of course, there was an injunction in Manatee County and some narrative. Dr. Russell, a forensic psychosocial mental health evaluation, I read, I think it was April 30th, 2020. She describes the abuse and domestic violence that Doug did against Ashley quite eloquently. It's quite clear the things she discovered in she did interview and come to that conclusion. So I found that kind of enlightening. There were telephone calls and documentation between Doug and Ashley. I've got a date of August 16th, 2019, where he was, controlling, intimidating, amidst of being outside her house, following her. He was gaslighting her. He pulled a gun on his ex. There was a threat that he was going to kill himself with a gun, and there was more. There's more in that without pulling out the document. There was a very significant WhatsApp phone messages between Ashley and Doug, and in that there's statements about being armed, that he talks about warfare, rage, exterminating them, murderous mood, anger to take them out. A warrior side would be, the testosterone rage, talks about killing bad people. So let's say we could say, was this all true? Or was this techniques that to put her in fear of him? Both could be true, actually. I found that very, Dr. Broder, I read his testimony and that he gave, and it was clearly domestic violence was present. There was definitely power and control tactics reviewed by him. The mic blow up, the gun incident was, and I have a quote here, was certainly a frightening experience for Ashley. Doug's temper, yelling, screaming, punching holes in walls, and Mr. Taylor's cross was in that transcript I read. And as you spoke to Dr. Broder, angry temper, very controlling, highly manipulative, very intense. The holes punched in the wall, fired a gun in the ceiling. That there was an appeasement. That word was even used by Ashley, apparently by Dr. Broder, as a strategy with Doug to protect her child, keep him at bay. This is the very issues I've been talking about. And there was text about him kicking the dog and throwing the cat between Ashley and Doug. So all these elements right here, I got my conclusion from. I didn't need anything else. And this is clearly what I base my determination on.
And would you conclude, based on what you know, that Ashley was an abused woman?
Definitely.
Would you?
And I'm going to interrupt you, Mr. Taylor. Abused woman is to say one thing, but abused woman who was in compliance mode, that didn't want to poke the bear, that was afraid of what might happen if she opposed him, that's what I get here.
And how, if at all, would that explain, for example, Ashley agreeing to go on a parental exchange between Doug Benefield and her daughter Emerson? Ashley, in the week leading up to the shooting, exchanging friendly, lovey-dovey text messages with emojis and things like that. And Ashley at a restaurant with her mother and her child Emerson in the company of Doug, acting happy.
Totally, it doesn't oppose my theory at all, or what I believe was going on. It may be that there's one thing I can say. Ashley did show from what I've read here and what you're presenting to me, a sophistication to, and maybe that's her performance side for being a ballerina or whatever, I don't know. But she could put up a good front. And this was to keep that warrior side of Doug at bay. She was concerned and afraid, and she was very afraid for her daughter. This is the mother factor. You know, her getting in that, I guess you referred to the first visitation.
Yes, at the sheriff's office.
Her going along, that's much like I talked about that wife that stays with the abuser to protect the child. The idea of letting him, have custody at that time without, and I don't think, if I remember from documents I read, they didn't have that. He didn't have a lot of exposure to Emerson, and so that was definitely the mother, the maternal instinct, wanting to protect her daughter, and at her own expense. But that's nothing. I'm a parent. I take a bullet for my kid. It's not about me. It's about protecting them. I think that mothers do that. That's what mothers do.
All right. Thank you, Mr. Ferris.
Mr. Ferris, it's always a little bit dangerous when the court has questions, because certainly I'm a neutral party here. But in this kind of situation, in a Daubert hearing, I'm both the finder of fact and the decider of the law. So there are a couple of questions I have. I have said this multiple times. Mr. Taylor, I probably said it in hearings with you. I know you two have heard it. If you object to one of my questions, please put your objection on the record. I have actually sustained objections against my own questions before. So I try to be intellectually honest, and if it's in retrospect, I realize that's not a good question.
You have been good about that, Joe.
First, I did not receive a copy of your CV in evidence. It may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? In my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy of it to verify that that's the complete version.
Sure, you want to see it?
Yes.
Absolutely. I'll say, Mr. Taylor, there's markings on it.
Yes, sir.
You don't need it back? Is it in the court file?
I don't know if it's attached
To the deposition, let me take a look.
So here it is.
No. I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red pen markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
If I may. It's the defense's burden. My only concern about your asking questions is that I understand what Your Honor, I have a guess as to what your questions will likely be, but that is my only concern. I don't know what objection that would be, but.
I mean, don't forget there's also the general and proper. So you object away.
Yeah,
You know me, I don't mind.
Yes, sir. Yes, sir.
All right, and then you had gone through a list of 13 things that you had reviewed.
Yes, sir.
And I was writing them down as we went, and I'm taking notes. I only got 12.
Okay, so do you want me to briefly?
I don't want the narrative portion.
No,
I just want you to tell me.
Or you tell me. Okay, I'll tell you.
No, it's got to be the other one. You have to say to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number 3.
A little slower.
Okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Broder testimony, and number 13 was the text, kick dog through cat, and between Ashley and Doug.
Can I just ask to clarify, you said phone calls between?
Yes, from 8/16/2019, I have a transcript of phone calls between them.
Transcript of phone calls?
I believe so.
No,
All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions?
No, sir, thank you.
Mr. Taylor, do you have any questions based on my questions?
no, Your Honor.
All right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay.
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you will be returning early next week.
Okay.
So stay in touch.
Okay. And so I'm still under my subpoena.
Yes, sir.
Thank you. Thank you. I do appreciate your attention.
Absolutely. Have a great weekend. Don't forget you've also got your wheel over here. Or was that yours?
That's theirs.
Okay.
I've got mine. Thank you. Thank you.
Sir. Safe travels back home.
Yes, appreciate it.
Well, we're looking you go right at the perfect time, aren't we?
Yeah.
Might want to stop and have dinner.
Or pack up my hotel room and put my blue jeans back on, right?
Yes, sir.
Thank you.
All right, the witness has left the courtroom. Did you have any other witnesses' testimony or evidence you wanted to put on for the Daubert hearing?
No, sir.
State, did you have any evidence, testimony you want to put on?
No, sir, thank you.
All right, I'm ready for argument.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows, provides if scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, and the court knows the three requirements, sufficient if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and three, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to the shooting. And included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug. Stephanie Murphy testified to they were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know and what the record reflects based upon Mr. Ferris's testimony and the Duluth Power Wheel and its model for the evaluation of domestic abuse is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. Keep it keeps the beast at bay. And now, that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, the jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So, here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But, as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. It carries over, and it explains under Duluth Power and Control Wheel why Ms. Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at the parental time sharing with Doug, why she would try
I'm sorry, but
why she would try to get along, go along.
but I don't want to bother you.
So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyand versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the second DCA.
Oquendo.
Yes. No, this is Wyand. Kathleen Wyand, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyand decision, Your Honor, was March of 1999. The Supreme Court rejected the second DCA's position in the Wyand case, and instead embraced another circuit's decision, and it turned on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme Court said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052, and the topic is Section B, Implications for Victims of Domestic Violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyand help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyand goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony. When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence, which is the overarching umbrella, battered spouse and those two components coming underneath it, you then go to Oquendo. And in Oquendo, they serve it up perfectly. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind to the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions, Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far, with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Ms. Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Ms. Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We are trying to meet it. That's our position.
All right, thank you. State?
Thank you, Matt. Judge, I'm going to try to bring it back to Daubert, but I do want to address Akendo because it frames my arguments. Sorry. Under the Okendo case, or Oquendo, however you say it, the court carves out, as we've discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that it's an objective standard. Self-defense is an objective standard, not a subjective standard, and that the one exception for that, and under Okendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome, and part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Whelan case also defines battered spouse syndrome. It says,
You want to spell it?
sorry, it's the case Mr.
Wyand?
I'm sorry, Wyand.
Whatever, however you want to say it. I see you know
I
which
don't,
one.
Biand, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important and the state asked it is because if he's evaluating her for battered spouse syndrome, which he clearly wasn't because he admits he does, that's not what he was doing. There's only two options for that, and your Honor's aware of that. That one, if she's evaluated, then they have to file notice and we are allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions, and professional, apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's a product. I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome. They have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met in the state's opinion is that it says if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder, and it certainly goes to her depraved mind, but the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this for scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but ultimately I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard. Thank you.
Rebuttal?
Mr. Ferris was asked directly if he evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that at no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense. However, self-defense is certainly a material element to be considered, and there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court, drawing a distinction between Daubert and the case law on battered spouse syndrome, I would suggest that given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raised about the go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, oh, well, this is not battered spouse syndrome, because for it to be battered spouse, you absolutely must have the abused party living with the abuser, having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility, and I would call him as an expert witness on domestic violence. And if the court really wanted to narrow it even further, as it relates to a woman who would choose appeasement and go along, get along. Coincidentally, I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomena. I think I need and I should be entitled to be able to explain that to the jurors, and I'm not going to be able to do that without expert testimony. So I think the state combined Daubert with the case law, and Daubert is the procedural vehicle for allowing for testimony.
All right, I do have some questions. I end the week, as I mentioned, at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, you filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote. Mm-hmm. And the reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those 2 elements. I shouldn't even say it requires those 2 elements. Those 2 elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said, as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence, because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt at the same time entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was to battered spouse or just as domestic violence.
All right. So we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve-out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about diminished capacity, right? Essentially diminished capacity, because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
All right. Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that it would take in order for the weapon to fire. And you call an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge, and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder who would not have that knowledge that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case.
I do not have a specific case on that point, no. And so the court knows I instructed Mr. Ferris not to evaluate Ashley Benefield. I had planned, if it came in under battered spouse, to follow the Heenan option, whereby he would be given a series of hypotheticals based upon facts and evidence.
Excellent segue, that was my next question. I didn't keep track on the clock how long Mr. Ferris testified about the general properties of domestic violence, Duluth wheel, cycle of violence, his numerous anecdotes, personal anecdotes, and relatable anecdotes. But if I'm understanding correctly, you are going to seek for him to offer an opinion that Ashley Benefield was an abused person and Doug Benefield was an abuser. Is that correct?
No, not necessarily. That was for purposes of the hearing that we had. It would be my plan, if he comes in under the Heenan approach to battered spouse, Your Honor, to just have him educate the jurors about domestic violence and specifically ask him about the compliance aspect that would allow a woman to engage in the type of behaviors that the state has raised the issue about and injected the evidence that they have. I could then give him hypotheticals based on facts that were in evidence under the battered spouse syndrome exception, or alternatively, were he to come in just as an expert on domestic violence, I had him review the discovery materials. As the court knows, he submitted to a deposition by the state under the Heenan approach or under just domestic violence expert. The state, as it says in the case law, would have had the option to get their own domestic violence expert. They haven't done that.
My ultimate question was, at one point you asked, can you relate these concepts to a domestic violence situation? Yes. He can study facts and documents. Can you relate these concepts to a situation where you study the facts and documents of a particular case? Yes. But you're saying you're not doing that way, you're doing hypotheticals. You're not going to render any opinions in this case.
Correct.
Specific to this case.
If it comes in under battered spouse syndrome, that's correct, Judge. I would follow the Heenan approach.
I think it's Hickson. Are we talking about Hickson?
No, I don't think it's Hickson. It is in Hickson, but the case is Heenan.
My question is this. He spent so much time on these Hornbook issues, and the question was asked, can you apply these principles to hypotheticals? But I didn't hear a single hypothetical that's going to be presented so I could even hear him and consider him and listen and see if he applied the principles, reliably to the scenario. So I have no idea, how am I going to make a ruling when I didn't even hear the hypotheticals?
Well, the hypotheticals would be based on evidence in the record.
I understand.
I took him up to that threshold and I asked him, could you reliably apply these principles to a series of hypothetical questions if asked? He said yes.
So why didn't you ask the hypotheticals so I could hear them and make a ruling?
Well, I would ask the hypotheticals, Your Honor, based on what we know is record evidence. For example.
Exactly. What's in the record, what's been admitted.
Correct. But that's.
Is it your position that all 13 of those items have been admitted into evidence?
No.
So I would need to hear the hypotheticals to know what you're going to ask about.
So I would ask the hypotheticals, Your Honor, based upon shooting the gun in the ceiling. Actually, I would ask the hypotheticals based upon the evidence that the state has presented to create the issue. For example, I would ask, in a week's worth of text messages were to be exchanged leading up to a shooting that show emojis and friendly banter back and forth, would that be inconsistent with battered spouse syndrome? I would then ask, would a woman who shares a child and the husband has a right to joint custody, and the woman agrees to go along with the husband when he is with the child, would that be inconsistent with battered spouse syndrome? And he would explain in response to those types of hypotheticals why it wouldn't be, why this issue of compliance exists and is so prominent in domestic violence cases or in battered spouse syndrome cases. I mean, the hypotheticals, I think, are readily available based on what we have, record evidence. Now, I might also add, Judge, we've only called, I think, 2 witnesses, so there may be more that's in the record. But to the extent that I'm interested in it, it will relate to this issue that the state is teed up about acting friendly and not being fearful being in the company of the individual. It doesn't mean that they're not fearful. Once again, Your Honor, I had him review the discovery documents in the event he came in as an expert on domestic violence and was going to speak to that issue.
All right, thank you, sir. All right, State.
I guess based on that line of questioning, I'm still not sure what the answer is to your first question, which is this a battered spouse syndrome case or not? I would argue that it is not. There's been no showing that battered spouse syndrome applies in this case. And I think that's my first argument. As to the hypotheticals that we did not hear today, the state objects to the hypotheticals being offered to this doctor because under Hickson, if this were battered spouse syndrome, which is really all we have for guidance, it would have hypotheticals are available to someone who has not evaluated her. And I think because I know he said he has not evaluated her, but the fact that he read 13 items in this case, he's wholeheartedly familiar with what the defense believes the facts are in this case. And I think it would then be inappropriate for him to be asked hypotheticals based on what is in the record, because clearly he got a lot of things that are not in the record. That's it, Your Honor. Thank you for letting me be heard.
Anything else we need to take care of before I let you go? When do you plan on calling Mr. Ferris?
I'd like to call him first out Monday morning, Your Honor.
Is there anything that I think they can hear Monday morning before us, or can we leave some of the things we've been leaving?
I'm not aware of any hearings Monday morning.
Okay, thank you, sir.
That one's turned off.